Hearing matter, my lord. Can this be, my lord, after the puja break? Okay.
May Your Lordship, I beg to mention item number 25. My senior is unable to attend the court today. 25. 25, Your Lordship, 25. 25. Yes, Lord. Your Lordship. Kindly list after the puja vacation. This matter. Yes, Lord. Your Lord.
Your Honor, this is a matter pertaining to violation of the status quo order by the respondent number 2 on behalf of the respondent number 3. Your Honor, the overview of the case. What has happened in this case is the petitioner as plaintiff has filed a suit before the Learned Court of Civil Judge, Karadati District at Palin at Camp 0, inter alia, for a declaration of right, title, and interest, and for confirmation of position, and for permanent injunction against the respondent number 4 and 5 hearing. The suit was registered and number as title suit number 01-2023. My lord, it may be relevant to mention that along with the suit, the petitioner has filed one application under Order 32, Rule 1 and 2 of the CPC 1908 for a temporary injunction with a prayer for grant of ad interim ex parte injunction, considering the urgency. My lord, thereafter, by order dated 12/6/2023, the Learned Court of the Civil Judge Junior Division, Karadati District, Falin at 0 Camp, was pleased to grant status quo order in respect to the scheduled land, and my lord, further directed the parties to refrain from carrying out any activity on the scheduled land. My lord, however, subsequently, a survey order dated 13 June 6, 2023, issued on 14/6/2022
What is
was
the order of the trial court?
uh,
Page number.
my lord, I'll come to that also. Page number 48, page number 48, Annexure E.
This is dated 12/6.
This is the status quo order passed by the Honorable Court below, dated 12/6/2023. And your order, my lord, will come to page number 50 of this order, status quo order. in the second, in the second, in the fourth paragraph. Accordingly, the petitioner has successfully established the prima facie case, valence of convenience and irreparable loss in his favor. Thus, the prayer for maintaining the status quo order is hereby granted. And accordingly, the parties are refrained from carrying out any activity on the scheduled land. The possession of the land shall continue on the basis of as is where is. My lord, thereafter, what has happened after this order was, status quo order was passed? On 13/6/2023, the respondent number 3 pass and survey order stating that Sri Deke Kana Mandal and Sri Dado Gungning chairman is hereby directed to conduct verification to the plot of Sri Takam Taing, wearing allotment number so and so dated 17 March 1999 and measuring 300 square meter for residential commercial purpose at Hinda 1 Palin, and to submit the detailed field report to the undersigned positively. My lord, may I appreciate this order was passed after the status quo order was passed. And this the status quo order was communicated to the respondent number 3, to the office of the respondent number 3. However, he refused to accept the same. My lord, thereafter on 14/6/2023, the respondent number 545 along with the official of the office, chairman and mandal, they went to the scheduled length of the petitioner and has done survey and demarcation upon the schedule in violation of the status quo order. And thereafter,
Only there is a injunction order
yes,
from the trial court. After this injunction order was passed, the survey order
yes,
has also been passed.
yes,
Is
my
the-
lord. And one,
He's appealing for respondents. Any response?
and my lord, one more order is there. Page number 52. This is a certificate on the basis of the survey and demarcation on dated 14. They have issued one pass one certificate
52 now, page number 52,
52,
19 June.
19 June 2023, declaring that the suit land falls behind the PWD store. So this two order was passed after the status quo order was passed.
You were appearing for respondent number 2. You were the relevant party most. What do you say? You see the language of the injunction order. Prayer for maintaining status quo is hereby granted. Accordingly, the parties are restrained from carrying out any activity on the scheduled land. The possession of land shall continue on the basis of as is where is. This is dated 12/6. This is order 13-6. Immediately pass the survey order. You could have even filed a appropriate petition before the trial court.
My lord, we have already filed a appropriate petition before the competent court
Uh,
for for initiation of for willful violation of the status quo order.
hmm. What is the order? Was the order passed by the trial court?
No, as on that, the trial court has kept the hearing for next date. It has not been heard till date.
Was the number then? Was the number? Number of the petition, the miscellaneous case.
My lord, I don't, I'm sorry to inform
In
that I
between,
don't.
you have brought this writ petition.
My lord, this writ petition is for, that is a separate proceeding and this is a
This
separate.
is also
proceeding.
separate. You have
Yes.
made it a separate proceeding. Already order is violated.
Hmm.
And in spite of injunction was there. So
And my
in
lord,
the meantime, you have filed another petition, again another. writ
and my
petition.
lord, what has
is
happened, they
this?
have,
You produce the certificate copy of the order of the trial court.
my lord, will produce that copy. In the meantime, interim may be.
Interim how?
Interim stay may be
How?
granted.
How?
Because, my lord, tomorrow is fixed for the hearing. And they have filed a misapplication for the dismissal of the suit on the basis of this order. And my lord, I have more than reasonable apprehension that if this honorable court, this order is not stayed, then my suit may be dismissed on the strength of this.
See, already one
order.
proceeding is pending before the trial court in regard to violation of this order. How interim order can be passed here? You have opted for that remedy. Civil court
My lord,
remedy.
that proceeding will be continued as a separate proceeding.
Wonderful.
But as on
Problem
now,
is that in between another writ petition, what do you say? Huh? But this is wrong, huh? This is wrong. On 12/6, that order, injunction order was passed. On 13/6, immediately another order passed by the authority.
my lord,
I have seemed to recall this order. It is repeatedly done here. Don't play. Issue notice. Obtain instruction next week.
my lord, I'm only praying for,
Let the trial court pass some order.
my lord, I have more than reasonable apprehension. It may be.
You see what is their intention, I have understood.
Hmm.
What is their intention? Although this is an order for survey, this will create another document. What is this?
Yes. Because if this order is not vacated and quashed, then because by this order, they have the respondent number 3 has already decided the right interest title over the suit land.
Yes. Are you appearing here?
Yes, Lordship.
For
respondent number 1. In fact, Lordship, this writ petition is not maintainable because here is the alternative remedy.
trial court is already seized of the matter. And tomorrow is fixed for hearing. In between, this petition has been brought.
Instead of filing this writ petition, Lordship, he could have filed
Yes,
appropriate
Yes,
petition, Lordship.
put, some hard work. now.
Even
If
contempt could have been
in
drawn.
drafting and filing this petition, let it survive for some days.
At this stage, Lordship, notice may be issued.
Notice has been issued. Take steps within 2 days. Justice service can be done, I think, on 4 and 5.
My lord, what if tomorrow my suit may dismiss on the strength of this order?
Procedurally, you think about it. Hmm.
at least short.
By registered
interim-
AD post? By registered AD post? Or dusty service?
Dusty service.
Alternative dusty service, notice by dusty mode on respondents number 4 and 5. Extra copy of the petition along with the document and therewith be furnished to the standing counsel. You write the inputs of the day. This is urgent.
My lord, if tomorrow, if my suit get dismissed on the strength of this order, then my right to
Don't worry, don't worry.
this writ petition
You
will
just
become
inform the
infectious.
Trial court that the writ petition has been filed here. This is the number, this is the petition, this is the order. This must. That may likely to help you to some extent.
At least till tomorrow, until the hearing.
Wrong, no? This is wrong for us. Yeah, after vacation, I think.
Yes.
In the meantime, you have to serve notice. No?
Yes, yes.
After
It may be
this,
taken
after
up after
vacation.
vacation.
After vacation. Next.
Highly hope.
May I please, Lordship,
Hmm.
Lordship petitioner is approaching this honorable court
Hmm.
for setting and quashing of a suspension order issued dated 9 January 2023. Lordship, may I kindly take Lordship the page number 24 of my petition? May I read, Lordship?
What is the impugn order 9/1/2023?
Yes, Lordship. This is the impugn order. May I read, Lordship?
Hmm.
What is the case against so and so in respect of offense in related to paper leakage of episode
Page number 25.
24, Lordship, 24. Yes,
24.
Lordship, yes. 2017 examination is
case
under
against
investigation by SIC, Itanagar.
Paper leakage.
Yes, Lordship. So this is,
Question paper leakage.
yes, Lordship.
Under investigation by SIC turnover and the junior engineer was detained in custody on 2/1/2023 for a period exceeding 48 hours. Now therefore the said Lotu, the junior engineer, is deemed to have been suspended with effect from the date of detention. Now,
Yes.
what is your prayer?
Yes. Now, Lordship, next, this next page is page number 25. Then the respondent has issued order for inquiry. Inquiry, Lordship. And petitioner appeared before the inquiry authority. Yes, Lordship. Petitioner appeared before the inquiry authority on 24/4/2023. So inquiry conducted. It's been more than 275 days. This order, this suspension order has not been reviewed. Neither this suspension order reviewed nor memorandum of charges issued to the petitioner. So indefinitely petitioner has been suspended. So I have approached authority verbally also, and Lordship representation was also submitted dated
You were
17/7/2023 for
suspended
yes,
with-
revocation.
All right. What is the date of suspension?
Lordship, date of suspension order is, Lordship, actually, petitioner was arrested on 2nd January 2023. And this suspension order was issued on 9/1/2023.
9/1/2023.
Yes,
With
the
effect
suspended,
from the
yes,
date of detention.
yes, yes.
Date
from
of
the date-
arrest.
Yes, Lordship. So it's been more than 275 days.
Yes. 45 we should not say like this. Not expensive. Page number. Page number 20, huh? 20, page number 20. Then issue notice. You were representing respondent number one. Huh?
1 to 4.
1 to 4 all.
And 5 is there, Lordship. One private respondent.
5 is not mentioned. 5, oh, serial number wrongly typed. 5. Issue notice to respondent number 5. You have already received notice?
On behalf of respondent number 1
Ah,
to 4.
1 to 4. Yes, so has received notice on behalf of respondent number 1 to 4. An extra copy of the petition along with the documents annexed to be furnished to him in the course of the day. Today you furnish copy to him.
Yes, Lordship.
Hmm.
Lordship, there is a clerical error of this.
I have
So,
corrected.
yes, I may be allowed to correct it.
Numerical figure, na?
Yes.
5.
Yes, much obliged,
Plus
Lordship.
vacation.
Yes, Lordship. Much obliged.
Mm. Item number 1. And appears for the petitioners. Name appears for, you are for
I'm for 1 to 4.
1 to 4. List. This is for admission hearing, na?
Yes, Your Lordship.
Yeah, no, see, none has appeared. After vacation.
Lordship.
After vacation, answering puja vacation.
No. Lordship, I need some time to file affidavit here.
For
Uh, For all the respondent. I have to file affidavit, Your Lordship.
You
I've
file
received the
affidavit.
instructions, yes.
Madam will file affidavit. After in the second week of November. Second week of November.
Lordship. Okay.
So yeah. None appears for petitioner on call. And so is present. You are for respondent
1 to
1.
1 to 7.
1 to 7. List. In the second week of November,
No issue.
is the interim order. On the last day too, he did not appear.
Your Lordship, may I submit? Your Lordship, through this petition, I am challenging the issue of no confidence motion, which was initiated against me. Now, the facts in this case, briefly, Your Lordship, is that on 26, I am at present, I was the Gram chairperson of the Kuskut Panchayat, which is in Yazali. Now, on 26/12/2020, I was elected. And then thereafter, I was the GPC, Gram chairperson. Then on 7/12/2022, one application was moved for no confidence motion against me. And basing on that application, on 29/12/2022, one notice was issued by the member secretary for no confidence motion. Now, what happened, Your Lordship, after that is that after this notice, the motion was not held. After this notice, on 29/12, notice was issued for no confidence motion. Now, after this notice, the motion was not held. And Your Lordship, technically, when a no confidence motion after issuance of notice is not held, then it is deemed to have been lapsed. But despite that, again, what the membership secretary did is on 13/1/2029, he issued one more notice for no confidence motion. And subsequently, on 21/1/2023, that was withdrawn by the applicants, saying that they don't want to move the no confidence motion. Then, very surprisingly, again after that, on 22/3/2023, one more application was filed by them for no confidence motion. And based on that application, one more notice was again issued to me. That is on 23/3/2023. This the last order, Your Lordship. That is the order I'm challenging to this petition. The 23/3/2023. Now, that notice, Your Lordship, will find in page number 27 of my annexure. That notice that is in page number 27 of my petition. The notice which I'm challenging.
The no confidence motion notice was withdrawn.
Yes. First, it was withdrawn on 21/1/2023. And after withdrawing, again, they filed one more application on 22/3/2023. That means after 2 months. That withdrawn letter, Your Lordship will say,
Withdrawn, it was withdrawn on 21/3/2023.
yes,
On the following day, another application for no confidence motion was filed
that was
on
on,
22/3/2023.
yes,
Against whom? Against you?
against me. Then basing on that application, again, notice was issued to me.
Please cause of action. On 3/4/2023,
Yes, then motion was held and I was disqualified.
you were disqualified.
Yes.
Then what is your grievance now?
Now, the issue that I'm raising, Your Lordship, is that the application was filed on 21/01/23 and notice was issued on 22/3/2023. Yes, it was filed on 22/3/23 and notice was given to me on 23, just 1 day after the application. Now, my first contention in this case, Your Lordship, is that if we look at the Arunachal Panchayat Act, which is in section 63, Your Lordship, section 63(1). May I read out the provision, Your Lordship?
Who is the Panchayat Act?
Volume 8.
It is here somewhere.
Volume 8, Your Lordship.
This is your copy.
No, that is not my copy. I have only one single copy.
Page number?
34. Section 63(1).
34.
Yes, page number 34.
Section?
63. Your Lordship, may I read the provision? 63(1), Your Lordship. Yes, Your Lordship, now.
So no confidence motion was passed.
Yes,
You are now out of the office.
yes. During the pendency of.
Now.
That order has not been challenged, Mr.
No, I was.
I will see.
No, Your Lordship, I was removed during the pendency of this suit. When this petition was filed, I was still in office.
Yeah.
Now the issue I'm raising, Your Lordship, is that if we look at the section 63 subclause 1, it says, Your Lordship, a motion of no confidence may be moved by 1/3 of the total members, total numbers of members of a Gram Panchayat or an Anchal Samiti or Jila Parishad against his chairperson after giving at least 7 days notice in writing to the member secretary.
Where is that?
Section 63, Your Lordship.
Huh?
Section 63,
63.
yes, of Arunachal Pradesh Panchayat Raj Act.
63.
In my volume, it is in page number 34.
Not less than 2/3. Where is 7 days notice is mentioned?
Your Lordship.
7 days notice.
Your Lordship, I'm sorry, I'm not getting the,
Huh?
what did Your Lordship say?
How many days notice is required?
Okay, okay, yes.
This is
Yes,
uh,
yes,
section
what I'm trying to
63.
say, section 63,
Where is it
yes, 63 subclause 1, Your Lordship.
Subclause?
1.
Jila Parishad and service after giving site.
Now, what I'm saying, Your Lord, if we look at this provision, Your Lordship, what I'm saying is that after receiving the application, there has to be a gap of at least 7 days in between receiving the application and in between issuing the notice of no confidence motion, which has not been followed. Because the application was received on 22/3/23, and on the very next date, the notice was issued. So there, as per this provision, there should have been at least 7 days time period before issuing the notice. There is one issue I'm raising to this petition, Your Lordship. And the second issue which I have come before this court, Your Lordship, is that now within a time period of 3 months, no confidence motion has been initiated thrice. And my submission is that no confidence motion cannot be initiated before that. Once a motion has been initiated against me, there has to be a minimum of six weeks in between before the initiation of second no confidence motion. The same procedure is followed in
But
the
first notice was withdrawn, no?
yes, but it was withdrawn, but then the notice had been issued to me by the member secretary, which means it has already been set in motion, already been initiated.
Yes. Government said.
If Lordship see the notice, Lordship.
Where is notice?
Notice is 8 page, Lordship, 27, Lordship. Annexure 7.
27.
Annexure 7, Lordship. If Lordship see the date, Lordship, it was issued on 23rd March 2023, Lordship. And no confidence motion, the meeting was directed to be held on Lordship, 3rd April 2023, Lordship.
Received. As policy will be 3rd appeal. 70.
And here around 10 days has been given, Lordship.
10 days.
10 days. This is
That is
sufficient,
minimum,
Lordship.
7 days.
No, what I'm saying.
And if Lordship see the section 63, what it says, Lordship, if 2/3 members, Lordship, out of total members, if they intend to move no confident motion, Lordship, then they are, Lordship, entitled to move that, Lordship. And here, Lordship, the total members are 10, Lordship. Out of 10, Lordship, 8 is more than, Lordship, 2/3 majority, Lordship. And subsequently, Lordship, that no confident motion has been held and he has been voted out, Lordship. Now, removal order has come, Lordship, which has not been put into challenge, Lordship. And so far, Lordship, once it has left, Lordship, no confidence motion can be conducted within 6 or 9 months, Lordship. That is not the language of the Lordship, this act, Lordship. It must be very clear on the act itself, Lordship. If Lordship see the section 63, Lordship, it talks about the Lordship, how many members are entitled lordship required to move the non-convenient motion. Only that has been given lordship. That accordingly has been done lordship. There's nothing wrong lordship in this. That's all.
You were
Order responding to 5 to 12. And we have a 10 out of 10.
respondents number
5
2
to
to
12.
5,
5 to 12.
5 to 12.
Yes, those are the mover against the
Mm.
motion who
Mm.
moved him out.
Mm.
So, lordship. Now I've already assumed and I've already inducted as a Gram chairperson in place of the petitioner. Since I'm counseling and in the due process, he has been voted out by the members in presence of the member secretary. Lordship. So, he has also not challenged the order of order the 3rd April. That is the order of this as per provision it's issued by this member secretary. That as per the provision of section 63 Arunachal Pradesh Panchayat Raj Act of 1997, the motion moved by the GPM as mentioned is found valid and successful. Hence, Srimati, the petitioner is then removed as a chairperson of 26 Kuchkut Gram Panchayat with immediate effect. So this is the removal order. So he
Page
has
number?
he is not annexed. The petitioner not annexed this order.
By the time this petition was filed, Your Lordship, I was still in office. So there was no question of annexing this order. It was only during the pendency of this application that I was removed. And since I'm challenging the order through which this order is passed, so automatically this comes into the within a fall of my petition.
Lordship, the petitioner has challenged only that in a month or in a year, we cannot move this motion against the petitioner twice or thrice. There is no provision. He has challenged that only, but there is no provision that motion against the petitioner can be moved twice or thrice. There is no such provision. So he has acted beyond the provision of this act. He has filed this writ petition beyond the act. Lordship. So this is better to dismiss for the interest of justice for a healthy democracy. Lordship.
Your Lordship, may I give some more submission? Now my submission is that as I was submitting, after the application, there has to be gap of 7 days before the member secretary issues notice, which has not been followed. It is a different thing that it was held after 10 days, but the notice has to be issued only after the lapse of 7 days, which has not been followed. That is my first contention. The second contention is that now, within 3 months, no converse motion cannot be initiated twice. That is my
First one was withdrawn.
yes, it was withdrawn. But the notice has been issued against me, Your Lordship, by the member secretary, which means it has already been set in motion. Although it has been withdrawn by the other party, but then officially it has been initiated against me. So on that basis, I'm submitting it cannot be initiated twice in a period of 3 months. Now, he has submitted that in our Arunachal Pradesh Panchayat Act, there is no provision that there has to be a gap of 6.
File affidavit.
Yes, no, he hasn't
Affidavit
filed.
is filed.
Lordship.
Have you filed affidavit?
Yeah, if
Only 3 is
Lordship,
here.
see, this is actually not necessary. Affidavit is not necessary at all because very clear in the earlier observation made by this honorable court.
Both of them.
Yes, Your Lordship. Because nothing is there in this case.
Your Lordship, I kindly permit me to give my submissions.
I've heard you at length.
No, Your Lordship, I have some more points, Your Lordship.
Some more points.
Yes, some case laws which I want to relate to.
All right, all right.
Now, he has said that in our Panchayat Raj Act, there is no provision for keeping 6 months time gap in between.
If you have any citation, please.
Yes. Now, what I'm saying is that all the Panchayat Raj Acts of different states, they have this provision that there should be minimum of 6 months in gapping in between 2 non-converse motion. Although it is not there in our Panchayat Raj Act. Now, in the absence of any provision in our act, then we can look what the provisions in other states. Like the provision in other states, you know, if we look at the Your Lordship, this Manipur Panchayat Raj Act, it clearly says that no converse motion shall yes, if the no confidence, if the motion of no confidence is once rejected, no fresh motion of no confidence shall be brought before the Gram Panchayat within a period of 1 year. That is in Manipur. Similarly, Your Lordship, in the Orissa Panchayat Samiti Act, there also it says the same thing, that once it has been moved or withdrawn or defeated, it cannot be moved within the period of 1 year. Then Himachal Pradesh and all this Rajasthan, all the Panchayat Raj Act says that it cannot be moved twice within a period of 6 months. Now, it is only in our state which we don't have this
Is
provision.
there any provision for rule of interpretation? Of
Your
this act?
Your Lordship,
Is there any specific provision for providing for interpretation of the provisions of this act?
yeah, yes, Your Lordship.
Notwithstanding anything contained in this, say, in this act.
Now, in that case, Your Lordship, let me permit me to rely on my case law, on case law,
Yeah, yes.
which of course I have already read in my earlier submission. This is the case law, Your Lordship, of the Supreme Court, which is which, of course this is of
What's the
the
citation?
citation name is Bipulbhai M. Chaudhary.
You just mention the year, volume, etc.
It is 2015 years. I have one copy for this court, Your Lordship, if you're. And Lordship, the relevant provision that I'd like to rely is that page number 17, Your Lordship.
This is of
15,
2015.
yes, Your Lordship.
Page number
15. 17.
17. Paragraph?
First paragraph, Your Lordship. Yes, yes. Whenever a statute comes up for consideration, it must be remembered that it is not within human powers to foresee the manifold sets of facts which may arise. And even if it were, it is not possible to provide for them in terms of free from all ambiguity. A judge cannot simply fold his hands and blame the draftsman. This is one point that I'd like to highlight. Now, through this point, Your Lordship, I'm saying is that now in our Panchayat Raj Act, that no provision has been made. But this provision has been incorporated in all the other Panchayat Raj Acts. Now, we cannot simply say that it is not in our Act, so we will not look into the other Acts, which is being prevalent in the different states of Arunachal Pradesh. Now, if the different states are following that there should be a gap of minimum of 6 months in between, that principle has to be adopted in our Panchayat Raj Act also. Because we cannot simply say that it is not here, so we will not interpret. Second point, Your Lordship, is that the last paragraph, Your Lordship. The last paragraph. Now that is court. May I, Your Lordship? Now that this court has declared the law regarding the democratic setup of a cooperative society, and that it is impermissible to remove an elected office bearer through motion of no confidence motion, and since in many states, the relevant statutes have not carried out the required statutory changes in terms of the constitutional mandate, we feel it just and necessary to lay down certain guidelines. However, we make it clear that these guidelines are open to the appropriately modified and given statutory say by the competent legislature or authority. Having gone through the provisions regarding motion of no confidence in local self-governments, we find that there is no uniformity with regard to the procedure and process regarding motion of no confidence. Some states provide for a protection of 2 years, some for 1 year, and a few for 6 months to the office bearer in office before moving a motion of no confidence. However, majority of the states provide for 2 years and a gap of another 1 year in case one motion of no confidence is defeated. This is what Your Lordship. Bihar Panchayat Raj Act 2006 provides for a protection of 2 years and 1 year. Bihar Municipal Act 2007 provides for a protection of 2 years and 1 year. Himachal Pradesh Panchayat Raj Act provides for a protection of 2 years and 2 years. Madhya Pradesh Panchayat Raj Act, Gram Swaraj Adhiniyam 1993 provides for a protection of 2.5 years. Madhya Pradesh Municipal Act 1961 provides for a protection of 2 years and 1 year. Manipur Panchayat Raj Act 1994 provides for a protection of 2 years and 1 year. Orissa Panchayat Samiti 1959 provides for a protection of 2 years. Orissa Grama Panchayat Raj Act 1964 provides for a protection of 2 years. Punjab Panchayat Raj Act 1994 provides for a protection of 2 years. Rajasthan Municipal Act 2009 provides for a protection of 2 years, and Uttar Pradesh Panchayat Raj Act 1947, as followed by Uttarakhand, provides for a protection of 2 years and 1 year. Now, Your Lordship, having regard to the setup in local self-governments prevailing in many states as above, we direct that in case of cooperative societies registered under any central or state law, a motion of no confidence against an office bearer shall be moved only after 2 years of his assumption of office. In case of motion of no confidence motion is once defeated, a fresh motion shall not be introduced within another year. This is the point which I'm focusing, Your Lordship. Yes, yes. So in this case, Your Lordship, it has been clearly guideline has been very clearly that in case once motion has been defeated, so fresh motion cannot be initiated within a period of 1 year, as per this case law. Now, this basing on this case law, Your Lordship, even in Gujarat, by one Gujarat High Court, this Shivangijam Chetan Patel versus State of Gujarat. Your Lordship, I have one copy.
Right.
University. In this case, the
Page number.
yes,
Page number.
page number 31, Your Lordship.
Para number.
Para number 43. There are lots of paragraph which has been mentioned about the citation just I referred now, but just I'll come to the concluding part, Your Lordship. The 43, Your Lordship. Now, Your Lordship, before I read the page, paragraph 43, I'd like to emphasize that all the provisions that has been mentioned in the previous case law, it has been relied on in this case. So in this, the 43 says, Your Lordship, under section 13 of the Gujarat Panchayat Raj Act 1993, every panchayat, unless sooner dissolved under this act, shall continue for 5 years from the date appointed for first meeting and no longer. Keeping such provision in mind and executive functions entrusted to the selected sarpanch under section 55 of the Panchayat Act and object of the 73rd Constitutional Amendment Act 1992, and continuity and stability of the appropriate Raj institutions, we deem it appropriate that reasonable time of 1 year should be considered as reasonable time, within which no motion could be permitted for removal of elected sarpanch by way of no confidence motion, as contemplated under section 56 of the Gujarat Panchayat Raj Act from the date of declaration of result. Similarly, once no confidence motion is moved and defeated, same cannot be permitted for a period of 1 year from date of defeat. This part, Your Honor, the last part. Now, the earlier case law was of the cooperative society, and relying on that case, this is a case of the Gujarat High Court. Now, Your Lordship may have the impression that the case law that I relied in the earlier time, it is only of the cooperative society, but that is not the so, because both are part of the part 4 of the Constitution, the Panchayat Raj Act and the cooperative society. Both are part of the part 4 of the Constitution of India. So it has to be followed by the same guidelines. And another point that I'm relying on, Your Lordship, is that even in Lok Sabha, once a motion is defeated or moved, it cannot be moved before the expiry of 6 months. So therefore, my submission, Your Lordship, is that the process which has been followed against me, it is illegal. Because without any consideration for the legal procedure, the persons cannot move no confidence motion 3 times successive, 3 times continuously in 3 months, your lordship. So this, the motion may be quashed and I may be reinstated to my previous position.
Anything?
Lordship, I want to add one point.
Hmm.
Since the first motion was not conducted, first motion notice was issued on 7/12/2022. And motion was not conducted at all. And there was some intervention of the political party to settle the matter. So we withdrawn. So motion was not conducted as part of past notice. And second, after withdrawal, again, the matter could not resolve within the petitioner and the mover. Then we again submit a application to the member secretary. That is on 22/3/2023. And thereafter, second notice was issued for conduct of the no confidence motion. Then motion was conducted on 3/4/2023. Then she was voted out. So no first confidence motion was conducted. That means there is no two confidence motion in the instant case. So there is only one confidence motion was conducted. That is second motion conducted. That is a valid one. And first was not valid at all because motion was not conducted. Only notice was issued.
Yes, your lordship.
Lordship.
That is the point, your lordship.
So this
Now-
case to be dismissed at right now.
The motion was conducted or no, that is not the issue, your lordship. The issue is that it has been set in motion officially. That is the issue I'm raising.
Much better.
These are new documents to me. No?
Now with this law, lordship, is about the law cooperative society. The law which has been placed by my friend also. It's about the cooperative society.
Yes, that is true.
The
But
logic is very simple, lordship. Because the action has been initiated and taken under the Arunachal Pradesh Panchayati Raj Act. We cannot go up for the lordship, the act enacted by some other state lordship. So it's not that lordship relevant.
now,
First, this no confidence motion was not acted upon on withdrawal.
It was withdrawn.
Only. Next.
And what it says, lordship, pass is defeated lordship. Then lordship, it
now
was the second.
my issue is
Anyway, lordship.
Wait, your lordship. Before my learned friend sixth time, your lordship kindly grants me 2 minutes. My lord, in 2022 September, around, there was a allegations of leakage of question papers by the Arunachal Pradesh Public Service Commission, some officials. Ultimately, my lord, they were arrested, trial going on, in some cases, investigations going on. But there was a huge public hue and cry. These petitioners are nowhere connected with the examination set. So succumbing to pressure, my lord, the government suspends everybody, including the driver, the sweeper also, including us. We are not even connected to the exam. We were just suspended on 29/10/2022, almost a year back. Till then, my lord, the memorandum of charges is not there. Till then, the memorandum of charges has not been served to us.
Framed, yeah.
Extension. On 17/8/2019, when this honorable court directed that bring instruction whether memorandum of charges have been furnished or not, the instruction has not come till that. On 29/2023, again 1 week time was granted, but this has come after almost 2 weeks. I understand instruction is not there.
When he was placed under suspension,
29/10/2022.
20.
Ajay Kumar
It's,
Chaudhary.
Joram Nagu, no?
Yes, Joram.
Where is the order, suspension order?
At page 25.
Orders, where is the secretary?
Under secretary establishment.
Action of
Those persons against whom allegations are there, they have arrested in custody now. Trial is also going on.
Okay. 29 and 22.
Well,
Place on the suspension. Is 25. All right.
there are-
When the charges were framed,
no, my lord. That is why we are before lordship. Around a year now, no charges, nothing. These cases are, my lord, squarely covered. Your lordship has passed judgment on that, my lord, while your lordship was here. I understand my learned friend does not have instructions. Let him have instructions by next Tuesday or Wednesday, my lord. It's a covered case.
This morning I have spoken to the official lawsuit. This morning I have spoken to the official lawsuit. It's under the law betting process lawsuit and it's likely to come by next week lawsuit. So I will be given 2 weeks time lawsuit.
2 weeks will make it go beyond the vacation, my lord. My lord, there's a decision by the honorable.
it is
Supreme Court.
already late now.
How can this be? Instruction, my lord.
If I am not wrong, charges ought to have been filed within 6 months or 3
90
months.
days.
90 days, 3 months.
Yes. My lord judgment, I
Days
have it here.
No, whether-
lordship judgment.
Whether it has.
No, that is just academic
Yes,
discussion.
yes.
So you want to obtain instruction?
Yes, yes.
Let it be
From
by,
whom?
From personnel department lawsuit. Now it has been already processed to the law department lawsuit for betting lawsuit.
Charges, this affidavit is
Betting
not
for what?
filed.
Not yet filed lawsuit. Therefore lawsuit.
Oh, affidavit would be required, no?
Yes.
my lord, what affidavit in such cases, my lord?
That-
Because only thing that my learned friend is to intimate your lordship is whether the memo now
Then the
charges.
whole matter will come to light. It is under obligation to file an affidavit. by the
My lord,
respondents. To
with
file
great,
it.
with great respect, my lord, in such cases, your lordship, including your lordship, my lord,
Yes.
has, my lord,
I
only
took
on the
the
basis of
provision,
instruction, my lord, dispose of such cases. Where's the question of filing affidavit in such cases, my lord? There's a
But he
decision
has
by
no,
the,
he has no instruction.
that's why I am saying, let the
Must be
learned
required.
friend seek instruction, my lord. Let it come
You
up
seek
Wednesday, my
instruction
lord.
then.
Lawsuit.
When?
2 weeks lawsuit.
My lord, next Wednesday, my lord. There's a decision of this honorable Supreme Court. How can they violate it like this? Notice was issued on 17/8, my lord.
Given. So, when this petition was filed.
17/8, my lord, the first notice when. Only for that instruction whether memorandum of charges is filed or not. Now another 1 month, my lord, we have to wait, despite there being a clear judgment of the honorable Supreme Court.
What,
My lord,
what is the position? Legal position?
legal position. 90 days automatic revocation.
It is there.
Hmm.
He is seeking some time
But my lord,
to.
my lord, will kindly see the order dated 17/8/2023. What is the instruction, my lord?
You know, na, when there is a proceeding, they will have a chance. for
I
hearing.
understand, my
That
lord.
too reasonable.
My lord,
opportunity.
My lord,
You have
if
already
it
obtained
was a
3
pro-
weeks time.
If it was a
But
promotion
still,
case, I could have
affidavit
understood.
is not filed.
Yes, this is coming for the third time only lawsuit. So
Huh?
it's coming for the third time only lawsuit. So I'm
With
just,
great respect, my lord. Whenever there's a stay order in a transfer case, my lord, they file it in 2 days.
Alright,
There is somebody,
alright.
there's a
Next week,
decision by the Supreme Court, my lord. and
lawsuit,
next week.
Next week, my lord.
2 weeks lawsuit.
But why is my learned friend
2
insisting like
weeks
that?
there will be holidays.
Yes,
From 14.
instruction as to whether memorandum of charges have been furnished or not.
You'll
Lawsuit.
file affidavit.
I have always sought for the instruction lawsuit.
You
Therefore, to
obtain
ensure
instruction.
lawsuit, it's filed lawsuit. I am seeking for lawsuit 2 weeks time only lawsuit. Hardly
lord-
10, 12
My
days
lord,
lawsuit.
instruction from Itanagar, my lord will take a call on Wednesday if it does not
Lawsuit,
come.
there's a process lawsuit. Law betting in all, there
If
some
for
sort of procedure is a lawsuit.
law betting
It's not
instruction,
that easily just submission lawsuit instruction has to be obtained directly from the authority.
with
It's not
greatest
like that
respect, my
lawsuit.
learned friend is defending the government is submitting something. May I make a
I'll
submission, my
give
lord?
you a fixed date, no?
My lord, may I make a submission, my lord? Your lordship can ensure that without even affidavit, the government bring the instruction on Wednesday. Why not, my lord? This has been done on earlier occasions.
Hmm.
The lordship can ensure that, my lord.
You obtain instruction the next week.
Next week, lordship,
Person is available. Person requirements.
as I'm submitting lordship. This morning I was spoken to the official lordship.
2 weeks
The
time.
file has been processed to the law department for their betting lordship, their opinion lordship.
That is most probably for filing of baby.
Today is.
Today is fifth lordship,
Fifth.
lordship.
The holidays, when it will open?
Starts from 14th, my lord.
14 to
6th November, my lord.
6 November. No, 6 November will be working day, I think.
It starts on 6th November.
By on 6th of November. On a very first day.
I know these
In
things,
the meantime, you finish. You.
Lordship.
my lord, greatest respect, these things should not be allowed, my lord. Somebody is under suspension for more than a year now.
Suspense, he is getting.
That is another thing.
75%.
That is another thing, my lord.
Hmm.
This government, it's a pleaded case, my lord. Because somebody is shouting, my
I
lord,
know,
they
I
place
know.
our suspension, my lord. What is this?
Listen, no?
For seeking instruction, my lord. This is, I am making
Instruction
this,
and file
this is,
affidavit metal.
I am making a submission as an
On
officer of
six.
the court, my lord. On various occasions, this honorable court, when the government has prayed for filing affidavit, this court has said, what affidavit? You only seek instruction whether the memorandum of charges will
In
be
some
furnished or not.
cases may be appropriate, in some cases may not be.
Same case, same case. I am
Then I will
Like-
dispose it of today,
making my submission on the same case.
if nobody allows time.
It is not, I am not, I cannot, my lord, I cannot say your lord, I am just making a submission, my lord.
Hmm. On 6th.
Lordship.
November. Submits that. The sufficient time was granted to the respondents to obtain instructions over the matter, but that has not been duly complied with. At least this Mr. Tuansu, that at least 2 weeks' time is required to obtain the instructions. Mr. Panging raises objection, submitting that in a number of cases, this court had disposed of such matters on the motion day itself, no?
Not on the motion days, on the
Yeah.
second day, on the basis
On
of
the
instruction.
second day. On the second day. Is upon. Has insisted for 2 weeks time. And in view of commencement of the ensuing Puja holidays. With effect from 14th of October. The matter is fixed on 7, no? I mean, 7.
Right.
6 will be the first day, no?
Well,
On 7. In a 7th of November. In the meantime, you are senior government advocate, senior, you are standing counsel,
Senior government. advocate.
senior government advocate. Shall obtain necessary instructions and file affidavit in opposition without fail. If so advised, no?
Loss.
If so advised, without fail. On 7, finished.
why not for disposal?
An endeavor shall be made to dispose of the matter on 7th of November. There is no serious any legal issue, only one point.
No, these cases, man, it's unfair, actually.
Oh,
No, on the part of the government, man. It's unfair.
okay.
Obliged.
Problem.
Is for. This is item number 9. Is it ready? Notice serve or not?
served you. It is appointment of arbitrator.
Hmm.
The opposite party has no objection
You come.
on. Yes.
Learned. Counsel for the appellate is present. None appears for the respondents. Leaves this matter in the second week of November. Second week, this is matter in the second week of November.
Okay.
What is your name?
B Kamdak.
Huh?
B Kamdak.
Kamda.
Yes. My lord. The brief
Notice issued for service on a respondent number 6, return served by office to dated 18/9/2023. On 7, notice not served. Respondent number 7,
respondent number 6.
6 is served. None appears. On behalf of respondent number 6 on call.
My lord. There
On
is
7,
Okay.
address he refused, na? Earlier, on 11/9, he shows postal but registered post. Received from CMJ Bomdila. Who is he? CMJ?
My lord.
CMJ? Or CJ?
DSGA. Khartoum, and Khartoum.
After duly causing service of notice
Yes.
on 6. But on 7, perhaps it was sent by registered ready post. It is returned with a postal remark, addressee refused.
Lordship, the learned DSC is taking a hearing at another court, Lordship.
No, all right. Simply no hearing will take place today. It is for order. Notice already served on respondent number 6 by officer 18/9/2023. 7 is not available. Addressee refused. That means it is duly served.
My lord, there is only 6 respondent, I think. 6 respondent only.
7. Respect to respondent number 6.
So one is 1 to 5, who is
Return,
Union of
all right,
India.
all right. 6.
And
There are
6 is-
6 respondents, no?
Yes, yes, my lord.
Only
6 is private respondent.
6.
Yes.
6 respondents are there.
Yes.
Notice served on respondent number 6. You are representing whom?
Union.
Necessary lordship will be.
But take a date because notice has been served. Let him prepare and appear.
After closure vacation.
Who is and 1, 2, 3.
1 to 5,
5.
Union of India, DSJ
And
represented
state
by.
is also there. ITBPO Central.
Yes, Union of India. This all 1 to 5 is represented by Lana DSGA.
But he is not available.
Yes.
None appears for the respondent side list. On the 3rd week of November.
Most of them.
11, 12.
My apply, my lord.
Notice served or not?
Yes, my lord. My lord, this matter contempt matter, my lord.
Contempt, a material associate has filed wakalatnama on behalf of respondent number 3.
And this matter, main party is respondent 1 and 2.
But you have implicated some other persons too.
Yes, yes, yes.
So they have become relevant. How many petitioners are there? Chaitanya Singh, Anurag J. Singh, S.K. Jha, Kalu Geran.
But in this case, main party is Malat, we have implemented.
You are representing whom? You are for?
Your lordship, in item number 11, I'm for the respondent number 3,
Your item number,
11.
this is item number 11, okay. You are
Yes.
representing
I'm representing respondent number 3,
respondent number 3.
Secretary Land Management.
Hmm.
And in item number 12, I'm representing respondent number 1.
Represented. And only
Yeah.
one,
Yeah, yes, only one.
respondent number 3 you are representing?
Yes, in item number 11,
Huh?
I'm respondent number 3, and in item number 12, I'm respondent number 1.
Wait. Yes,
I'm for representative number 4 in item number 11
for
for deputy commissioner. And in item number 12 also for representative number 2, that's the deputy commissioner.
3 and 4 are represented today. Others 1 and 2.
1 and 2 is by CGC, Malat. CGC Kato is the representative. So in this,
It is for orders, no?
they are represented, Malat. So Malat, in this case, only this respondent number 1 or respondent 2 has to deposit money before the deputy commissioner. And then direction was that it should be deposited within 1 month, but then it's almost more than 1 year. Malat, I'll just take to the operative person, Malat.
This is per
Yes,
day
yeah.
for them.
So next,
No, they have been appearing, Malat.
Interim order is there.
I think only they reflect.
This is,
Order, yes.
No, interim order is not there. I just confirmed from the client who is representing in the Supreme Court. In that matter, there is no interim order, Malat.
the conclusion of the proceeding of SLP or the modification of the order dated 21/3/2023 by the Honorable Supreme Court in SLP it shall be apprised.
That
to
was the
this
last
court.
order, Malat.
Shall be apprised to this court. This is the relevant order, no? No,
I think this Honorable Court also recorded in the.
yes, recorded, but.
Yes.
Decision. The owner should be, SLP shall be apprised to this court.
Yes, Malat.
What is the,
But I just confirmed from a client who is representing the Supreme Court. He is just informed me that there is no stay order in that matter, which is pending.
no, verbally.
But it's still pending.
Matter is still pending. That is not out, Malat.
Hard so and so. It is submitted. Perusal of record shows that by order date 25/4/2023, this court directed the petitioners to apprise this court regarding the outcome in SLP C number 4873 of 2023 under consideration of the Honorable Apex Supreme Court. However, the learned counsel for the petitioner submits that he is informed over telephone by the concerned engaged counsel in the Honorable Supreme Court that no stay order has been passed in this regard by the Apex Court. In that view of the matter, a latest copy of the order of the Honorable Supreme Court be made available on the next date. To file a copy.
And Malat, in this case, the money is in the case which is pending in the Supreme Court. Money is deposited before a deputy commissioner. The issue is on the disbursement.
Technical aspects are there.
But in this,
Please furnish a copy of the latest order. What is the order?
No, in fact,
Final
my-
order.
yeah, I will do that. My submission here, just in this matter, just my submission is that depositing money is there's no issue, especially with the,
Submission was already made on the last occasion also, Lordship.
in fact, Kato should have been present, my lord. They are side with the petitioner, my lord. They are ready to deposit, but the deputy commissioner is not giving the account. That was the last submission, my lord.
The
That
concern
was,
here-
that was last submission.
They are very much sympathetic towards the parent.
Yes, sir.
They will do that. Although.
They are delaying, my lord.
Although it is off the record.
They are delaying almost 1 year.
Next time.
Oblige, my lord.
Okay. Third. It will take time. Second is not third is there. Third is not.
My lord, this case is relating to non-payment of compensation in the construction of road, my lord.
Lordship, I have received the rejoinder. I have seen the rejoinder this morning only, so I need some time.
Draft receipt or final?
No, they have
You-
filed
you-
rejoinder. They have
Oh, file. rejoinder.
replied to my affidavit, Lordship. So I need
Next
some
time,
time.
The copy of the rejoinder affidavit is received today. So and so, learned the advocate seek some time.
Yes.
Okay, go beyond.
My lord, let this matter be listed for admission hearing.
Only release this matter for admission hearing in the second week of November.
Yes, Lord.
Oblige.
Obliged.
Some order was passed. 16. Some order was passed. In 16. You inquired from this. 16 some order was passed. So take note. Somebody moved it. Who is appearing in item number 16?
Lordship.
This matter has been adjourned, no?
No, my lord. We have
Somebody
not-
mentioned, I think.
I think we have not
You
mentioned.
have not mentioned.
No,
You are for the respondent
No,
side.
sir.
Petitioner side, I think.
No, my lord, I am for a petitioner.
Last time. I mean,
Who mentioned? It is tick mark, na? Tainted. Already tainted.
We don't have any knowledge, my lord.
Tara is not seen today.
okay.
What to do? What is the position?
My lord, may I, my lord?
All have received notice.
No, my lord, this affidavit has not been filed by the respondent number 1 and 2, my lord.
Lordship,
fact, my
we
lord-
have already filed the affidavit and Lordship, the court order was also complied, Lordship,
Huh?
in the contempt, Lordship.
Now contempt has to, my lord. has
There
to-
by respondent number 1 and 2, affidavit is not filed.
Not
Filed,
filed, my
Lordship.
lord.
Filed.
And their affidavit is required, my lord.
Uh-huh.
My lord,
Is
may
filed or
come-
not? Is
Not
filed or
Filed,
not?
Lord.
Filed.
No, my lord. Item number 15, my lord, the main writ petition, my lord.
No, Lordship, in
Item number 14, I'm taking.
14, the contempt, my lord, yes, they have filed, my lord.
They have filed.
Yes, my lord.
Affidavit is filed.
Item 15 is the main writ petition, my lord.
Item 15,
Yes, my lord. Writ petition, my lord, 478.
478.
Yes.
478. Here,
My lord, may come to please page 45, my lord.
wait.
Respondent
First
one.
notice, whether notice is completed on it.
My lord, standing council is there, my lord. Land management.
Yeah, Lordship. Notice standing council is appearing before the court number 2.
Standing counsel for respondents number
1 and 2, my lord.
1 and 2.
He has to file their,
Then 3, 4,
3, 4
5.
has filed. 3, 4
3,
has
4, 5 file
filed.
affidavit.
Yes, my lord.
3, 4, 5. But 1 and 2, then not necessary.
1 and 2 affidavit is required, my lord.
Hmm.
Because, my lord, why, my lord? The notification was
You
issued
are
by.
your name? M? Right. I can't pronounce. I like 1 and 2. Represents the respondents number 1 and 2. In item number, in WPC 478. Where you file affidavit?
Lordship, will file.
You file affidavit after vacation.
Yes.
Huh? Otherwise, process will not be complete. Second, third week. Third week of November,
My lord.
winter.
My-
Third week of November.
Obliged. Apply, my lord.
17.
Well, in this case, service report of respondent numbers 5 is awaited, madam.
Mm. Who is appearing for respondent number 5?
It's, we have taken step, my lord.
You have taken step, but
Yes.
not returned.
Yes, no return.
Notice issued for service on the respondent number 5, not returned. Await for service report. Others,
Others presented by the government, madam.
you were representing respondents number?
Lordship,
Only one remains now. Yes, Mo?
3, 4 and 5, Lordship.
3, 4 and 5.
Lordship. We have received the instructions, Lordship. We will be filing.
Seek instructions.
Lordship,
3, 4, 5.
On the behalf of Mr.
All right, all right.
Respondent
Respondent number?
2.
2. File affidavit, huh?
Yes.
2, 3, 4. Await for service report on respondent number 5.
Stay may we continue. Stay may we continue.
Huh?
Stay there.
Stays there. The interim stay interim order passed earlier shall continue till then. Third week? All right.
Lordship, this matter will pass over for timing. Leading counsel is taking him.
Order
I-
matter, no?
Yes, Lordship.
Order matter. Notice serve or not?
Notice, sir.
You don't know. All right, let me see the notice. Affidavit in opposition filed by respondent numbers 7 to 12. What about 1 to 6 then?
But you asked for the writ petition.
Hmm.
Lordship, I'm praying for some time. My senior D. Mazumdar is appearing in this matter.
Hmm?
Lordship, my senior D. Mazumdar is appearing in this matter. He is not present here today.
You want time?
Yes, Lordship, we want some time.
Go to then November.
We have already filed the objection in the IA.
It is there to petition. I. You have filed I.
No, we have not filed the, we
You
have,
filed.
they have filed the IA.
What is the prayer here?
It's for implement.
Any parties and after hearing be pleased to allow this application for implement of respondent number 7. Is there any objection for implement?
Lordship, perhaps there is some objection. My senior
Well,
wants to
you
ask.
filed an objection or file already filed. 7 to
Objection is already filed,
12.
Lordship.
Already filed. Okay.
It must be listed for hearing.
Then second week, second or
week of-
third week,
Third week of November,
third week of November. Some problem.
if
is
possible,
there.
Lordship.
Longer day. Okay, in the second week of November.
Much obliged, Lordship.
Pardon me.
May I sign, my lord?
Hmm.
But pleading, my lord, is over in this case, my lord.
Pleadings-
Pleading, my lord.
pleadings
Is
completed.
complete, my lord. Today, my humble submission, my lord. Let a record, my lord, pertaining to this NIT, my lord, be called for, my lord, and next date, my lord, this may be fixed in the admission column, my lord, for
I have
disposal, my lord.
objection, my lord.
No objection.
I have objection, my lord.
Why?
Is there any interim order?
Interim
interim
order,
order.
no interim order.
Then how there can be any objection?
My lord, now, what I am saying, my lord, affidavit, we have filed affidavit. The main contention, my lord, of the writ petitioner, my lord, will be perused, your lordship, in page number
Counsel, see,
45.
there is no stay order, there is no interim order. He is seeking some time, give some time to.
No, no, my
Well,
lord,
we have filed
my lord,
affidavit.
I am praying, I'm not praying time, my lord. I am saying, my lord,
This matter can be disposed today itself, my lord.
for proper disposal, my lord. A record would be required, my lord. Where record would be required, my lord? I am praying for the calling of
Which
record in the.
record?
There is no record, my lord. That's why, my lord, I am praying today, my lord, as pleading over, over, my lord. Let the record may be called for. Where, my lord, record is necessary in this case, my lord. Now, the case is about, my lord, tender, my lord. My lord. On the record, my lord, I am the L1, my lord. I am the L1, lowest bidder, my lord. Now, they have declared the L2 as a L1, my lord. On the ground, my lord, saying that, my lord, the L1, my lord, would not be decided on the base of, my lord, on the basis of amount put on tender, my lord. That would be decided by looking into the market value, my lord, of the item rate, my lord. Therefore, my lord, I am saying, my lord, if you are deciding the right, my lord, of some body, my lord, on the basis of market value, my lord, there should be some material and documents, my lord, whereby they have decided the market value of the item put in tender, my lord. Until and unless there is some record, my lord, this item rate, my lord, market value, my lord, cannot be decided in the closed room, my lord. Therefore, I am saying, my lord, to proper decide of this case, my lord, record would be required, my lord. Now, what
Original record.
yes, my lord, record pertaining to this tender, my lord. If they are saying, my lord, normally, my lord, any tender, my lord, would be decided on the basis of the amount put on tender, my lord. But they are saying, no, but they were not decided on the basis of the amount put on tender, my lord. They had decided on the basis of the market value calculated by them, my lord. Therefore, I am saying, let their record, my lord, calculating the market rate, my lord, of the item, my lord, be put before this honorable court, my lord. Ultimately, any tender, my lord, there should be transparency, my lord. That is the rule of the law, my lord.
My lord, may please
So
come to
what is
page
the
40.
ground, my lord? They are reluctant to, my lord, produce the record of before this honorable court, my lord. I am not saying let it so to me, but let this be record
Everything is here,
before this honorable court, my lord.
May I, my lord, page 40 of my affidavit in opposition. I would read only one paragraph.
The counsel for the petitioner says that the original record has to be looked into.
My lord, may please come to page 40, my lord. It will clear your lordship, my lord, of my affidavit in opposition filed by respondent number 1 to 5, my lord. Page 40, my lord. Everything goes clear by this clause, my lord. Page 40, my lord.
I am not disputing, my lord. I am not challenging their ground also, my lord. I am not saying, my lord, they have no authority, my lord.
Page number only 38
40, 40.
of your affidavit.
Affidavit in opposition filed by respondent number 1 to 5, my lord.
1 to 5, 40.
Yes, my lord. Page 40, my lord. Clause 14, my lord, of the NIT. Merit, my lord.
L1.
L1 will be analyzed on the basis of lowest rate quoted by the bidding firm on maximum number of items on justified rates, not on cost put to tender, my lord. Quote, not on cost put to tender, not, my lord. It has to be on the basis of justified rate.
Unrealistic.
Yes, my lord.
Yes,
On each item, my lord. Now again, my lord, quoting unrealistic rate in any items without words and overall valuation beyond 5% of justified rate shall be rejected. Now, we have to see what is his justified rate, my lord. He has quoted some rated more than 1,000%, my lord. Beyond the market value.
So an analysis of all the bidders.
Yes, my lord. It is there, my lord.
Yes, my lord. Truly, my
It
lord.
is a
I
written
am
petition.
I am not.
Ascertain
Yes,
whether there was any unrealistic rate
Well,
as referred to in rule 14.
Yes, my lord. Page 68 of the writ
Page
petition is there, my lord.
I have annexed the whole those documents, my lord. I am not challenging this condition also, my lord. I am saying, yes, they can settle some justified rate, my lord. But that should be that justified rate, my lord. Ultimately, by this justified rate, my lord, you are giving some tender to some person, my lord. This justified rate based on market value cannot be
calculated in the closed room, my lord. There should be some basis on some record, my lord. How they have called determine the market value, my lord. That's why I am praying record may be called for, my lord.
Learned counsel for the petitioner emphatically submits for a just disposal of the instant petition. The relevant, relevant original record may be required.
Of justified rate, my lord. Of justified rate. Market
You
rate.
produce the whole file, no?
Yes, my lord.
That's it. Upon hearing the learning counsel of both the sides and perusal of the affidavits filed by the respondents, this court finds it expedient to request the learners counsel. Your government.
Yes, my lord.
Government.
Yes,
Your
my lord.
Standing counsel.
Standing counsel.
standing counsel.
Yes, sir.
Counsel for
Respondent number 1 to 5, my lord.
1 to 5 to produce the original record, relevant record on it will go, you have for private respondent. You repeat for private respondent number 6. After before petition, no. Second week of November or the date. Second week. Huh?
My lord. Obliged, highly obliged.
My lord. Obliged.
Order matter is fixed.
Yeah, your lordship. Lordship, I'm appearing on behalf of the conducting counsel B. Sarma. So in this matter, there are 5 respondents. So he had paid that 3 weeks time may be granted to take steps upon the private respondent number 5, your lordship.
Your name?
My name is not there in the Wakalat Nama. I'm only appearing on behalf of B. Sarma, your lordship.
You stay. You are for
My lord. I'm for respondent 1 to 5.
1
Oh,
to
sorry,
5.
1 to 4, my lord. 5 is private respondent.
1 to 5.
1 to 5.
Mm.
1 to 4, yes.
And
5 is
6, there is no 6. 1 to 5 complete.
5 respondents, your lordship.
5 respondents. He is dispensing.
1 to 5. 1 to
1
4.
to
1 to 4, my lord.
1
5
to 4.
Yes.
1 to 4. 5 is private
5 is
respondent.
private respondent.
Right, absolutely.
Notice serve or not?
My lord, they have not yet served. My lord.
Today we have.
Steps be taken for service of notice. Fresh steps.
Yes, your lordship.
On for service of notice on a respondent of 5 by registered AD post. Not return, huh? Notice not return.
And also your lordship may direct them to file the furnish as the requisite copy, my lord. Requisite copy. They have not.
That has been done.
They take that responsibility.
I said requisite copy, not only 1 copy. You have made 4 respondents.
That we have done it today itself, your lordship.
Huh?
We have already served the requisite copy. 3 copies has already been served.
3rd week of November next.
Yes.
In the meantime, requisite number of copy of the petition along with the documents annexed there which we furnish to the learned counsel or you are standing counsel or what?
No, my lord. I am appearing as an additional advocate general. my lord.
Additional advocate.
Yes.
As before.
Yes, my
As
lord.
before.
Long time, my lord.
Additional advocate general appearing for the respondents. 3rd week of November.
Yes, your lordship.
This is matter. You furnish copy.
Your lordship, that has already been done today itself.
A requisite number of copies because
Your
so
lordship.
many departments are there. Within 1 week you will furnish.
Yes, your lordship.
Huh?
Yes, your lordship.
Obliged.
Obliged.
Hello. So this is regarding non-payment of pension lawsuit. Here lawsuit petitioner was retired in the year of 2019 lawsuit, and it's been more than 4 years lawsuit. He has not been paid his pension.
Why you are not paid with pension then?
Lordship, there is.
Service books are ready.
Yes, lawsuit. Lawsuit, according to them, lawsuit, the petitioner was drawing excess salary lawsuit. So after recovery of the excess salary, his pension case will be settled lawsuit. But here lawsuit, my
Excess salary, how much?
lawsuit, That I have no idea.
That-
Lordship.
that-
Not a certain yet.
In any case, Lordship,
Office is Lordship fixing it, Lordship. It's taking time, some time, but.
If excess amount was done, it has to return.
Lordship-
Excess
Yes.
is beyond rule, no?
yes, Lordship, here my submission is that, Lordship, that excess salary has been paid because of the wrong calculation of the respondent authorities, Lordship. So, Lordship, for the error committed by the respondent authorities, Lordship, petitioner should not be made to suffer, Lordship.
And,
Lordship,
And
that
Lordship-
cannot-
And Lordship,
you see, I'm not
That
going to
cannot-
dispose of your matter, but it is not the rule.
no, Lordship, it is the settled
If I
position of
draw-
law.
No.
If I draw an excess amount,
This is-
wrongly amount,
But
was
Lordship-
drawn, I have to return.
Lordship, it is the settled position of law that
Okay,
after the
then-
retirement of the employee, Lordship, excess salary cannot be recovered, Lordship. There is series of judgment,
Yeah.
Lordship,
So
by the
then-
Honorable Supreme Court.
At a
Lordship.
time of final payment of pension, amount has to be taken into consideration.
Lordship, they have taken enough time, Lordship.
All right, all right.
Lordship,
Okay.
he's
Hardwick-
he's an
Hardwick
IS of retired IS officer, so his payment withdrawal statement has to come from Delhi Jal board. Jal board.
But
Yes.
you have you
Lordship,
filed
that's why it's taking
affidavit?
time.
Have you filed
Lordship,
affidavit?
affidavit is not required, Lordship.
Sorry.
Huh?
Jal board.
Affidavit is not required, Lordship, in this case. And
You
Lordship,
want to, no, why the
Lord-
pension is
Lordship-
not paid?
Lordship, we are fixing after the excess withdrawal, Lordship, is coming from Delhi Jal board, so it has come, so department, Lordship, personnel department is, Lordship, I'm in receipt of a, Lordship, letter from the department.
then Lordship, this matter may be disposed of, Lordship.
No, no, Lordship.
Like this hurriedly.
Yes, this can.
Since
be
they have
disposed of.
received the instruction, Lordship.
You have received instructions.
Yes, Lordship. Then
Instruction.
Lordship, this matter may be
With
disposed of.
reference to your letter number, it is to inform you that the excess drawal amount in respect of serious is being calculated by the bill branch on receipt of this drawal statement from Delhi Jal Board. His pension paper will be submitted to the DAP. DAP means Department of Pension.
Audit and pension.
Audit and pension,
Audit
Lordship.
and
Director of
as
Audit
soon
and
as the
Pension, Lordship,
calculation
not
recovery
department.
of the excess drawal is done. That means excess amount is yet to be
Calculated, Lordship.
Calculated, that is
Yes.
the stage.
After this is done, Lordship, this, his pensionary, Lordship, all the documents.
You
that
do
will
it
be-
within 10 days?
No, Lordship, it takes time, Lordship.
Hmm?
It takes time, Lordship.
They have
This
lo-
will be again given.
Lordship, they
to
have
the-
taken
No,
enough time, Lordship.
calculation-
The petitioner was retired in the year 2019, Lordship. It's been more than 4 years, Lordship.
Lordship, he has been paid, but then this is pension, but then he has been paid this one. Gratuity and
But the
other,
question is
Lordship,
whether plus the excess amount or minus the excess amount. That question lies there.
and Lordship,
Lordship, because
releasing of
45
gratuity
give us
doesn't mean
45
that they
days,
have right
Lordship.
to withhold my pension, Lordship.
Lordship, give us 45 days more,
Pension is
Huh?
my right, Lordship.
45 days more to the department to do the calculation and send it to the director audit pension. Lordship, this is from the,
Uncertain order cannot be passed. It must.
all right, Lordship, on, then I will bring the Lordship.
A vague order, if passed, it will not be carried out.
See, keeping this matter pending will not serve any purpose,
In
Lordship.
various
On next date, Lordship,
judgments.
on next date, I will, Lordship.
Where you pay the effort we made to pay the pension amount.
That Lordship will,
Huh?
Lordship, we cannot keep his pension. We are not keeping also,
In
Lordship.
that direction, this petition may be disposed of.
Yes, Lordship. Lordship,
This is personnel department.
Calculate and pay the amount as per rule.
Lordship, payment will be done by the Director of Audit and Pension. After calculation is done,
That's
the,
on the respond number 2.
yes,
You are
Lordship.
repensing?
yes,
All,
Lordship.
but Lordship, this I am for, this is from personnel department, Lordship.
No, you are repensing whom?
Personnel department, right?
All
now.
the parties, I think.
All the parties, but Lordship, here,
All the parties.
yes,
Then including respond number 2, audit and pension.
yes, Lordship.
Yes, Lordship.
How many days will be required to pay pay the disburse the pension amount to him.
Lordship, audit and pension will take some time on their own, Lordship.
Time within the matter of
Personal,
half an
personal
hour, na, for
department,
them.
Lordship, they will send the documents, proper documents after,
That is up to you.
After-
It is your
after the
department.
calculation,
See, he
Lordship.
is waiting for pension since 2019.
that's true, Lordship.
Huh? Disposal. Within how many days?
Lordship,
40, 45 days?
no, Lordship, 60 days in that case. If Lordship, since
You
Audit and
see, they are expert in calculation.
Lordship, audit and pension will take some
Because
time.
there is no objection from your side that the AC, that service books were not up to date. There is no such complaint from your side. So it has to be calculated and give the pension within 45 days. 1.5 months, sufficient.
That is enough, Lordship.
For
Enough time,
personal
Lordship.
department, it won't take much time, but then audit and pension, they will need some time.
Make it faster. There is order from the High Court, respect it. This much only.
Yes.
Lordship,
If you are unable to pay the pension, then here's the consequence what to do.
Lordship may
Law says so.
dispose it of saying that Lordship giving
45 days,
60 days time, Lordship.
60 days.
Yes, Lord. 60 days.
Huh? All right, 60 days time will be done.
Lordship, much obliged.
Even Lordship, 45 days is enough, Lordship, more than enough, Lordship.
60.
Don't stick to that. I'll dictate you.
Lordship.
Any more?
Early obliged.
Obliged.
Pay pension to people.
Malat,
What is server?
Malat, in this case, if you Lordship will peruse the office note from 13/12/2022, we have taken steps on the respond number 3. But the office note also indicate that neither the AD nor answer copy, no information about the.
No office notice. There is no office note.
No, there is office note saying that notice was sent by the registered post, but no
Not
informations, not
Not
returned,
returned.
not returned. But he is aware that much as personally.
You personally.
So in that case, Malat, to be in the fair side, I may be given
Some more
another.
time, some await for service report.
No, otherwise, I may be allowed to take another fresh
Taxi
step.
service,
Fresh step
trace stage, okay, by registered at the post.
by registered the
Okay.
post. And government has filed their affidavit. I may be allowed to file my rejoinder.
Rejoinder. That's a notice issued for service on a respondent number 3, na?
3.
3, by registered at the post not returned. In view of above, petitioner shall take fresh steps for service of notice on a respondent number 3 by registered AD post.
Yes, Malat.
Steps be taken within 2 days. And in the meantime, the petitioner shall file rejoinder. Rejoinder, if any. So and so, you give the names. Are present.
3 weeks after
3 weeks, list after, in the 2nd week of November or 3rd week, 2nd week of November.
Second,
Ek jo lagi bolu.
29. Notice item number 29 is this, Lordship, if you Lordship recollect, day before yesterday, a bunch of cases were disposed of. My lord, this is
29.
But yes, pertinent to non-payment of admitted liability.
By admitted liability that yesterday
Yes,
somebody mentioned.
yes, my lord. The same,
But the problem is that the security and earnest money.
my lord, that will automatically be released once this is payment is done. Because once the work is complete.
Yes, But that amount has also been calculated, na? While claiming the amount, although their work is yet to be completed.
I don't think so, my lord.
That part has to be minus.
Minus earnest and security.
That will be released after clearing the pending bills.
My lord, those are separate.
Minus the security and earnest money.
Yes.
That will be released only after work is completed,
After
completion of the works.
no such order is required. Say in the present year, this amount, undisputed amount.
Yes.
Minus the earnest and the security. Both are different, no?
Yes,
Yes.
Minus.
my lord.
This much.
Yes, this much, my lord.
But I think your figure shows including the earnest and this security amount.
But this 29.
Do you have any objection against grant of this amount?
29, in case of 29.
Hmm.
Although
What is the amount? What is the amount?
balance amount is 4 crore 26 lakhs 90,000. But he is entitled to receive 3 crores 14 lakhs. Still 1 crore 11 lakhs work has to be executed.
Then minus this earnest and security.
That is different.
That is, my lord, these figures are minus security and earnest money.
Oh, then no objection, I think.
No objection, but this amount has, pending bill amount has to be 3 crore, not 4 crore.
No, let them do the calculation when they are going to pay. So.
Oh, then this is disputed.
Annexure 4 is admitted, annexure 4. As per annexure 4, it should be.
Then order will be such that only the undisputed amount shall be this.
Yes,
Yes,
undisputed is 3
Huh?
crore.
Achha.
Annexure 4 is has to be considered.
Annexure 4.
Yes. This is the RTI reply to the
Annexure 4. Balance payment 4 crore 26. The SIC clearance letter exposed. Pending bill, this amount
yes,
is undisputed.
undisputed.
What, undisputed amount. Reference is
You see,
WPC.
undisputed, no? Page number 19.
19.
Page number 19.
Serial number 4 is.
I was confused now while hearing the matter. After taking up the matter, the earnings and security, whereas the projects are not completed. I was confused.
Look,
So-
this payment.
No, regarding the other matters.
Yes.
Yes, yes.
I kept the matters pending. I thought of that learned governments, this government side say that it is undisputed. So amount has to be paid. But when look into the other documents,
Yes.
I found in some cases that even the security and earnest money were also included in the claim.
That has to be excluded, my lord.
Now I cannot.
That is.
Yeah, I cannot. Understand this.
That is totally
You do
separate.
it, in your office, it's the same order.
Oh, yes.
3 crores, huh?
Obliged, sir.
Madam wants to say?
I'd like to mention a matter to be listed for Monday.
Which one?
It's a pending matter.
Pending matter, which one?
It is unlisted today. It has to be listed on Monday on.
No, please don't mention. It should be the mentioned at 10:50.
Then I'm aware because I missed out for a little bit.
You are so young now. Always maintain discipline. Huh? Only very serious matter only entertained. No? At 10:15 you mentioned tomorrow. Oh, the other side is not available. And it's back also okay. Alright, none appears for the petitioners. You note down his name. You are for
State respondent. State respondent.
state respondents. After long interval, no? After about 5 years. I am coming. List. In the third week of November,
Yes.
third week?
We have already filed our affidavits.
Uh-huh. This is fixed for hearing, no? Today.
Yes, sir.
Alright. In the third week of November.
Yes.